Freedom of religion, understood as a liberty, precludes the state from compelling an individual to engage in a religious practice and from restricting his or her religious practice without a legitimate public reason. In later judgments, however, there has been a shift in the court's description of the interest protected by the freedom, from liberty to equality. A third approach has emerged: selective or sectarian neutrality. The Charter is supposed to protect citizens from compelled belief from the government, but it has now been used by the government to deny fundamental freedoms afforded by the Charter itself. Under Section 1 of the Charter, the government can limit the Charter or rights if the reason is justifiable and reasonable in a free and democratic society. A private institution is not subject to the Charter. Trinity Western University, for example, is not subject to the Charter. Yes, the majority of the Supreme Court of Canada judges ignored the fact that Trinity Western University is not subject to Section 15 of the Charter of Rights and Freedoms. Judges Cote and Brown state that only a selective reading of the Law Society Act could support the Law Society of Upper Canada's position. They state that the Law Society Act does not grant the LSUC the power to regulate law schools, including their admissions policies. LSUC's functions, duties, and powers start at the licensing process, the doorway to the legal profession, and not at the doorway to the law school. The Federation of Law Societies of Canada argues that a central feature of Canada's legal system is that the public has the right to obtain legal advice and be represented by a legal profession that is independent of the government. They state that their laws provide for the self-regulation of the legal profession and that the function of law societies is to regulate the legal profession in the public interest. Here are some ways that the majority and dissenting judges' views differed on the question of public interest. The decision by the Supreme Court of Canada has extended the self-regulation of law societies into the context of accreditation of law schools. The Law Society now decides who can and cannot practice law in Canada. To be accredited, one must give up one's religious freedom for the sake of the public interest, however that is and will be defined by the Society. Anyone who does not abide with their definition is disqualified from practicing law and pushed out of the legal public square. The Supreme Court ruling has in essence handed law societies in Canada the power to dictate what values are to be held by lawyers, which in turn impact the religious diversity of the bar and the public they serve. Adequate accommodation of religious differences by the law societies will continue to be a challenge due to unequal application or protection of charter rights. The Supreme Court has shown that overly broad interpretations of terms in laws pertaining to their own profession can be adopted. The Supreme Court of Canada's website states, "The independence of the court, the quality of its work, and the esteem in which it is held both in Canada and abroad contribute significantly as foundations for a secure, strong, and democratic country founded on the rule of law." Elsuk's win shows the Supreme Court's lack of effort in trying to come up with solutions that accommodate for religious differences. The undermining of religious freedom and lack of attention to building a secure, strong, and democratic Canada is concerning.